pronounced Mcoo.
Yes, ma'am.
And generally speaking, I appoint the public defender's office to represent at least at the arraignment stage, but I was informed that you didn't want to speak with the public defender, so are you intending to represent yourself for the arraignment?
I'm here to figure out what the charges are. What am I being charged with?
Danny Mcoo.
All right. Ready for preliminary examination, or at least to deal with his motions? What are we doing?
Would the court be so kind as to make the self-representation inquiry, and
Yes.
perhaps we could look at the motion first?
Mr. Mcoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer.
Let's break this down. The charge. Resisting and obstructing a police officer, a felony, punishable by up to 2 years in prison and a $2,000 fine. And Daniel, as usual, is unrepresented. This isn't his first rodeo, and Judge Boyd knows it. When the judge asks if he understands the risks of going pro se presenting himself, Daniel gives the green light. But here's the thing. If you don't even know how to serve discovery properly or what suppression motions require, representing yourself is like stepping into a courtroom with a blindfold on and hoping for a miracle.
Now, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrong.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry.
Judge Boyd is trying to give Daniel a shot here, but it's clear this guy has no idea what he's doing. He wants his bond conditions lifted, doesn't know what procedures to follow, keeps apologizing as if that's going to help his legal case. When the judge calls him out, he admits he's only here because he was told to be. The vibe? Total deer in headlights. At this point, Judge Boyd is already warning him. This is going to be a long and painful process if he keeps winging it.
To do that, I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you
later
request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney.
Here we go. Daniel cites Miranda v. Arizona, the landmark case about being read your rights. But what's the problem? He tries to use it to suppress body cam footage without understanding the burden of proof or proper procedures. And when asked what Miranda actually says, he completely fumbles. Pro tip, throwing out random case names doesn't make you a lawyer. Judge Boyd sees right through it. And if you're wondering whether the court will teach him how to do this properly, spoiler alert, they won't.
Prior to being detained, I have not. No.
And you ask them, how do I get discovery?
No, I will be doing
Did you
that.
ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm gonna, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either.
Discontinue all hearings until there's substantial evidence. What even is that? Even Daniel admits, I don't know either, Your Honor. At this point, he's just tossing legal words into the wind like spaghetti against a wall. Nothing is sticking. Judge Boyd, somehow still composed, gives Daniel his constitutional space, but it's clear the courtroom is now a legal daycare. Should courts have the power to step in when someone is clearly this unprepared? Let us know in the comments.
Out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to
going
do?
home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor?
The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. All right.
What do I want to do?
Here's what I'm going to do. What are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work away.
Here's where things get fiery. Judge Boyd straight up says, you think you know what you're doing, but you don't. And honestly, he's right. Daniel's logic is collapsing. He asks the court to find him guilty during discovery, which isn't how it works and can't articulate what outcome he's actually after. This is no longer about justice, it's about clarity. We're not getting much of that.
And do you wish to be represented by an attorney?
I do not.
Okay. Motion denied. You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences.
Here's where things get fiery. Judge Boyd straight up says, you think you know what you're doing, but you don't. And honestly, he's right. Daniel's logic is collapsing. He asks the court to find him guilty during discovery, which isn't how it works and can't articulate what outcome he's actually after. This is no longer about justice, it's about clarity. We're not getting much of that.
Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
Thank you, Your Honor.
In your order, for the record, I put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about his case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. So I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Let me at least have some turkey before I have to deal with this again. December 5th. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings, you decide that you wish to be represented by counsel, cannot afford to hire counsel, then an attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different.
And here it is, the sovereign citizen reveal. Daniel declares he is not a ward of the state, denies committing any crime, and starts citing corpus delecti like it's a get-out-of-jail-free card. For the record, corpus delecti refers to the principle that a crime must have occurred for someone to be charged, not that a dead body is required, as some sovereign citizens believe. This moment. It's peak courtroom delusion. And Judge Boyd, she's seen it all before.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do. Your Honor.
Daniel now claims
Do you
that
have
unless there's
all
a
of
body
the
of a crime,
discovery?
he can't be charged.
I was just submitted
He
an audio
pushes back
file
against
this
arraignment,
morning, Your Honor,
suggesting
from,
he's being held
prosecutor.
hostage.
However, it's
It's classic sovereign citizen
correct
rhetoric
or something. It's not
default.
going through. I'm trying
Confuse,
to get a
delay.
valid copy from her. But other
But
than that, I
here's
believe
The
I do.
legal reality. The
That's
court
correct, Your
doesn't
Honor. We
need
did
you
send
to
over an
agree
audio
with the
file this
charges.
morning, and I did see
They
the
just
defendant
need you to
reply that he was
comprehend
having
them.
trouble playing it on
And
both his
Daniel's
laptop
refusal to
and
acknowledge
on
basic
his,
definitions puts
phone.
everything on hold.
I will note it. I'm just seeing today, it looks like the defendant may have a MacBook. And I know that those can have a little bit more of a difficult time with some of the audio files that come from my office. So that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of.
I believe it's the 911 call that brought the officers to the scene.
Now calling case number 25S00289. This is the state of Michigan versus Daniel Ryan Mcoo. Can you please state your name for the record?
I'm trying to figure out what the charge is.
Yes, that is the purpose of the hearing today. So as
Who's
part of,
the complaining victim?
as part of the proceedings, can I have you please state your name for the record?
My name is Daniel Mcoo,
Okay.
and I am
thank
not
you.
a surety of the state. I'm not a ward of the state.
Okay.
Can I ask what the charges are?
Yes, I am getting there. Please give me a moment. So What we are here for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So, what I have here is a misdemeanor complaint that charges that on or about
With a
or
mix of
between
disbelief
the
and
dates
resignation,
of February
Judge Boyd finally
15th,
says what we're all
2025
thinking.
and
We will
June
not be proceeding
23rd,
today.
2025.
Daniel is
You
free to
did
go, at
maliciously
least for
use
now.
a service
But don't
provided
mistake
by a
that for a win. It's
telecommunications
refusal
service
to engage
provider
with the
with
process.
the intent to
May earn him a
terrorize, frighten,
competency
intimidate,
evaluation,
threaten,
a delayed
harass,
trial,
molest,
or
annoy, or
worse.
disturb the
And that
peace and
file full
quiet
of discovery,
an
he's
individual with
struggling to
whom you
play.
have a child in common.
That's the least
By
of his
using
problems.
any vulgar,
He came in
indecent, obscene,
unarmed
or
to a
offensive
legal war.
language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is otherwise known as malicious use of a telecommunications service. Do you understand what the charge means?
I do not understand that. I do not understand malicious use
Let
of a
me
telephone
rephrase.
service.
Do you comprehend that what I am saying is that you allegedly maliciously used a telecommunications service device that would generally be a cell phone. I suppose it could also be a computer or something else
No, that
you
didn't
could
happen.
use. Okay. And again,
February,
as I
what were the
stated,
dates? What dates?
between February 15th and June 23rd
Of this
of
year?
this year. Yes. Okay. Now, as I stated at the beginning, I'm not asking you if you agree with the charges. I'm not asking you if you understand why you're being charged with them. What I want to know, basically, is do you know what the words coming out of my mouth mean?
No.
Okay. So the way that this is going to work is this. If I am not able to arraign you on the charges because I can't tell if you understand what I am saying, then the next thing that happens is that you get referred for a competency evaluation. At this point, I do not know how long that will take, and that means that you will stay where you are.
So, what did we just witness? A defendant trying to outplay the legal system with buzzwords, confusion, and sovereign citizen ideologian getting methodically dismantled by Judge Boyd, from misunderstood motions to failed legal citations. This case was a masterclass in why self-representation can go terribly wrong. Judge Boyd stayed calm but firm, drawing a line between legal rights and courtroom reality if you found this case as wild as we did. Make sure to hit that like button. Drop your thoughts in the comments. Was Judge Boyd too harsh or totally justified? And subscribe for more jaw-dropping courtroom breakdowns every week. You don't want to miss what happens next.